It is covered in Part 3rd of Indian Constitution, and the article which it contains are from 12 to 35. This part is very important from the point of view of prelims as well as from the mains examinations. We will, in this today's lecture, we will see all the important articles thoroughly so that it will be easy for you to solve all the questions in a right way. Okay, no? So first of all, before starting the definition of fundamental rights, I will give you some example with the help of which it will be easy for you to understand what is the fundamental rights, what are basic rights, and why they are also known as natural rights. So example is like this. One boy is there, his name is Aditya. He want to marry a girl who belongs to different religion. Now the family members of that Aditya's family, they are opposing to that marriage because she belongs to different religion. Now Aditya is arguing that it is his basic right, it is his fundamental rights to choose to the girl with whom he want to marry. This is one example. And second is, there is a name girl Rajpriya. After her completing engineering, she wants to go to Australia for further studies and for her employment opportunities also. But her family does not support her. They are against her decision and they want her to stay in India only. Now she again arguing that it is her fundamental right to go to abroad, to pursue her career, to utilize her potential in the right direction. These were two examples. What we understood from these two examples? We understand that fundamental rights are important for the dignity of the individual, for a person to utilize his potential in a holistic development, for his holistic development. This is importance and significance of fundamental rights. And all the citizens of India, due to the presence of constitution, they have enshrined fundamental rights in that, and they are available to every citizen of this country. And some rights are also available to people who come from different countries. It was all about the introduction of fundamental rights. Let's see the definition of fundamental rights. Fundamental rights are the basic rights enshrined in the Constitution of India, which are guaranteed to all citizens. What are fundamental rights? These are basic rights without which a human cannot survive. For example, right to food, right to equality, lot of other rights are there. For example, someone says you that you cannot walk on this public road. That is a violation of your fundamental rights, because like all other citizens, you have a right to walk on or use all other public properties. So it is the importance of fundamental rights. And if we see the history of fundamental rights, the first written source is that Magna Carta of 1215. Magna Carta of 1215. It was passed by or promulgated by the ruler of United Kingdom. And that's why, due to this nature only, fundamental rights are known as Magna Carta of Indian Constitution. What are they known as? Magna Carta of Indian Constitution. Now we'll look into the different features of fundamental rights, without which it will be difficult to understand what the fundamental right is. First is that they are justiciable in nature. What do you mean by justiciable in nature? The justiciable in nature means if someone has creating obstacle, you utilizing your fundamental rights, stopping you to enjoy your fundamental rights, then these rights can be enforced by the courts. What can be the? These rights can be enforced by the courts. In case of violation, a person can approach court of law. And in this regard, there is an Article 32 that gives power to Supreme Court for constitutional remedies. And on the other hand, Article 226 gives constitutional remedy to people through high courts. And the other features of the fundamental rights are they are not absolute in nature. What do you mean by not absolute in nature? It means that there can be certain condition in which your fundamental rights can be taken. For example, during lockdown, people were asked to stay in their home and they were not allowed to assemble, which is one of the fundamental rights. It was done for the broader welfare of the society, and also in other case, in the case of emergency. And mainly external in nature. In this situation also, fundamental rights of the people can be taken to ensure the unity and integrity of the nation. So we have seen that they are not absolute in nature. One more important thing is there. They are negative as well as positive in nature. Which means there are certain fundamental rights which stop the state. State here means government authorities to do not do certain tasks. On the other hand, there are positive fundamental rights which do not curb or put any restriction on anyone. It was about the nature of fundamental rights. So till now we have seen that they are justiciable in nature, they are not absolute, and they are categorized into mainly two categories, that is a negative as well as in positive. There are apart from this, there are a lot of other characteristics of fundamental rights which we will discuss as we move on along with the fundamental rights. Now, how many fundamental rights are there? In how many categories they have been divided? We will now look into that direction. When the Constitution was commenced, there were about 7 fundamental rights. But one fundamental rights was revoked in the year 1978. So at present, there are 6 fundamental rights which are as follows. First one is right to equality. It is from Article 14 to 18. And second one is right to freedom. It is from Article 19 to 22. And there is a third article also, right against exploitation. 23 and 24 are included under this. And another one is right of freedom of religion. It includes Article 25 to 28. Next is cultural and educational right. It includes 29 and 30. We will discuss them article by article. Right now I am just telling you how many fundamental rights are there. Next one is Right to constitutional remedies that we have discussed little ago, it is in under Article 32. And I was talking about one fundamental right which was revoked, that is right to property. Till the year 1978, it was a fundamental right. But through the 44th Constitutional Amendment, this act was changed, transformed from, or inserted in as a Article 300A as a constitutional right. Constitutional right, but not as a fundamental rights. The rights which are included in Part 3rd, they are known as fundamental rights. And the other rights which are included apart from Part 3rd in the Constitution, they are known as constitutional right. Till now, everything is clear about this division. Now we will move ahead. As we have seen that Part 3rd starts from Article 12 to Article 35. So what Article 12 talks about? Article 12 talks about the different important definition, one important definition, that is about the state. And here the meaning of state has been taken in a broader sense. You do not have to consider the meaning of state simple to that state of UP, Punjab, Haryana. That is not. Here the state is taken in a broader sense. For example, under Article 12, what the state means? State means legislative authority and executive authorities. Under it, it includes parliament as well as state assemblies. And under it includes, along with executive, it includes different bodies such as public sector units, the main crux of this Article 12 is that all the authorities which are directly controlled by government or semi-directly controlled by government, or they are under the domination of government, they will be considered as a state. For example, right now I am teaching in a 𝐼𝐸 Academy. Will be it considered as a state? No, it will be not considered as a state because it is a private body. Now I hope the difference between state and a private body is clear. Now we will talk about Article 13, which is one of the most important article of the Indian Constitution. Now we'll see what Article 13 talks about. Article 13 provides the power of judicial review to the judiciary. In what context? Article 13 says that Supreme Court or judiciary can check the constitutionality of any act which has been enacted by either legislative or rules which have been enacted by the executive authorities. It can be also any body which can be included under the state that we have talked under Article 12. We will deal the definition what is included in Article 13. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom, usage in the territory of India. Okay? And law in force includes law passed by or made by legislature and other competent authorities that we have talked about right now only. Before the commencement of the constitution, it also includes the law which were enacted during the British period also. It not only talks about the laws which are enacted in the present time. Article 13. It gives power to the judiciary that it can bring down or cut down the acts or amendments, even the legislative acts which act transfers into the or abrogate the fundamental right of an individual. It can be explained with an example. For example, this is the law, or here is the fundamental rights or the constitutional provision. If that law is inconsistent with the constitutional or fundamental articles, then Supreme Court will cancel or this law because it ultra violates the constitutional provision. This power is given to judiciary through the Article 13 of the Indian Constitution. I hope till now everything is clear. I can explain you with example. For example, if court makes legislative or executive authorities make any law which stops you from doing certain acts which is legal in nature, which is creating impediment from you to utilizing your potential, your rights, then that act will be taken away or abrogated or repealed by the judiciary. It was all about the Article 13. Now we are starting with the Article 14, which falls under the right to equality. Now what Article 14 says? You have to understand this article in very deep because it is one of the most important article in all the constitutional fundamental rights which we are going to discuss. Article 14 talks about equality before law. Its simple meaning is that everyone, whether you are chief minister or president, everyone is equal before law. So you have to think that right to equality means everyone is equal before law. What more it talks about? It says that the state shall not deny any person equality before law or equal protection of law. We will understand these two terms right now. Within the territory of India, it's give direction to the state government or union government, you can state that it should not discriminate between its citizens and provide them right to equality in front of law and also promote equal protection of law in territory of India. One of the important concepts that is also associated with it is rule of law. We need to understand it in deep. What do you mean by rule of law? Now we will talk about rule of law, which is associated with Article 14 of the Indian Constitution. Rule of law. This concept was given by 𝐼𝐸 who was the famous jurist. And I will explain this concept with the help of example. One side we are keeping that it is India, and other side we are keeping it is North Korea. Here is what rule of law is there. But what is here? Here is dictatorship. So what happened in India? The country is governed by rules and regulation which are formulated by legislative and executive authorities. Okay. But in North Korea, his dictator Kim Jong-un, whatever he decides, in whatever decision he takes, whether they are right or wrong, people have to follow them without questioning them. But in India, people have certain safeguards so that state cannot become a dictator in nature, arbitrary in nature. This is what rule of law. In mains exam, a direct question comes. In India, we have a rule of law. Analyze how rule of law is important for the society. You should prepare with a multi-dimensional, that in from a single topic, multi-dimensional question can be formed. It was all about rule of law. Now we have just seen two terms, equality before law and equal protection of law. Equality before law and equal protection of the law. What these two terms means? Equality before law means absence of any special privilege in favor of any person. Means all are equal in front of law. This concept was taken by the British from Britain, and the another concept is equal protection of the law. It was taken from the USA. And what is equal protection of law? It means the similar application of the same laws to all persons in a similarly situation. For instance, if we are talking about teachers and on the other hand we are talking about lawyers, we should not see them in equal. If teachers, they are different in situation, and lawyers, they have a different situation, so laws will be different for both of them and implementation will be according to their situation. So they should not be treated equally unless the situation is equal for them. Okay, I hope you understand the meaning of equal protection of law and equality before the law. Now we will talk about the Article 15 of the Indian Constitution. What the Article 15 says? Article 15 says that prohibition of discrimination on the grounds of religion, race, caste, sex, place of birth. Means state or any other individual person cannot discriminate on the basis of caste, color, class or place of birth. For example, in India we have seen the untouchability, where the people of so-called upper caste and so-called discriminate with the so-called lower caste people. This is against the Article 15 of the Indian Constitution, because it says that it prohibits the discrimination on the basis of different things. This article has also provided right to the state or parliament that it can make special provision for women and children. As we have seen that there are different legislative as well as executive provisions for the welfare of children and women. This is done under or done by the government under the Article 1503. 15.3. This article provides power to the union for two states to create a special provision for the welfare of women and children because they are vulnerable section and they often face discrimination in society. That's why Article 15 has given power to state to make special provision for them. Now we'll come to Article 16 of the Indian Constitution. Now, first of all, what Article 16 talks about? Article 16 talks about equality of opportunity in matters of public employment. Means, if there is a talk or any vacancies of public employment, that is government vacancies, then every person, whether me, you or any other person is there, everyone should be treated equally. That is enshrined under constitutional article number 16 of the fundamental rights. What is given here? That state should prohibit discrimination in the case of public employment. There are certain exceptions also in this article that will be going to look now. Now 16A, sorry 16.4. As we have seen in the Article 15 that the state has a power to make a special provision for women and children. Similarly, Article 16.4 provides power to the state to make a special provision for the reservation of appointment or post in favor of any backward class of citizens. It also includes both SC, scheduled caste and scheduled tribe people because they are backward in comparison to the mainstream society. So it allows government to make provision for reservation for them. It was all about 16.4. Now there is 16.4a. What it talks about? It talks about any provision for reservation in matters of promotion to any class or classes of post of services. Till now we have seen that there can be a reservation for job. Now this article provides power to state to make provision for the reservation in the promotion also. In different department, promotion is given to officers after a certain period time. In that case also they can get reservation in promotion because it has been seen that people of certain categories were not getting their due representation at the higher level. That's why this provision was added. One more thing I would like to discuss. In Article 15 as well as in 16 especially, we have seen that there will be no prohibition or discrimination on the basis of caste, class, religion, place of birth. But there are certain exceptions are there. What are their exceptions? For example, in many states there is a requirement of domicile. In union government also in some vacancies there is requirement of domicile. For example, if you are going to fill a form for any northeastern state, then they may demand for domicile because they have a different cultural identity, and if you do not have any knowledge about their culture, how you can do job over there? So domicile required is mandatory for such job. Second is religion. you may think that how religion can be a criteria for any job. There are many government jobs. For example, in army, there are certain vacancies of Purohit, Pujaris. So for them, government specifies that a person should be from Hindu society. Person should be from Hindu religion. Because Purohit or Pujari can be only from Hindu religion. That's why government makes religion as a criteria. There are few more exceptions are there that you have to study from your book. I am not going because it will become too exhaustive, and it will take if I will teach each and everything now, it will take in week to finish only fundamental rights because it is too broad in nature. Now we are moving toward next article. Next is article number 17, which talks about abolition of untouchability. What it talks about? Abolition of untouchability. You know, untouchability is one of the big problem in Indian society, and it has a long history. You will study about it in your society lecture, in your social justice lecture. Here we are dealing with the only constitutional article. So we will not go in a deep history of what untouchability is. But here we will discuss that untouchability leads to development of lot of disability. Development of disability. This disability can be of different type. For example, it could be of mental disability, physical disability, economic disability. For example, if you are discriminating with any person, then it will cause a mental agony to that person, that will cause him mental harm. How physical? In earlier days, what used to happen? The people of certain castes were not allowed to use public places such as water bodies, temples. That may create social, economical and lot other type of disability in their life. So Article 17 was added in the Indian Constitution to do away with the problem of untouchability. In this regard, Government of India has enacted many acts. In the year 1986, Civil Rights Act was also enacted in the year 1955 to do away with the problem of untouchability. Now we will talk about Article 18. What the Article 18 talks about? Abolition of titles. During medieval era and during British era, what we have seen that the people who are associated with the British were given certain titles such as Rai Bahadur, Diwan, etc. These were titles given to the certain people who were associated with the British, and this created inequality in the society because they used to utilize or this article to exploit the people, common people of the country, as a result of which these were abolished when Indian Constitution was formed. And one more reason was that when Indian Constitution was formed or we were independent, then there was equality, that everyone is equal. Then why we should give titles to anyone? So this was abolished because of this reason. But there are certain titles such as Paramveer, Bharat Ratna, they are allowed to people because that recognize their work for the welfare of society that they have done or contribution that they have made toward the society. So if the question comes that Article 18 of the Indian Constitution denies the title of Bharat Ratna, Paramveer Chak, all those articles, then that statement will be incorrect. And one more thing, this article also says that no Indian shall accept any title from the foreign state. Foreign countries usually also give titles to people of other nations. But this article says they are not allowed to do so. So we have seen Article 18, it talks about abolition of the titles. So till now we have covered from Article 12 to Article 18. Now we will stop from here, and tomorrow we will start with the Article 19 of the Indian Constitution. Thank you guys and have a nice day.